Hello everyone and welcome to this webinar on making mediation work for states and investors. My name is Frauke Nitschke. I'm Senior Counsel at the International Center for Settlement of Investment Disputes, as you know, ICSID. As I'm sure most of you are aware, ICSID provides an independent forum to arbitrate, conciliate investment disputes. ICSID was established under the Convention on the Settlement of Investment Disputes between states and nationals of other states, the ICSID Convention, an international treaty that entered into force in 1966. To date, has been signed by 162 states and ratified by 153. For the past few years, ICSID has been offering assistance to parties wishing to resolve their dispute through mediation. This topic will be discussed today with I'm joined here by Wolf von Kumberg, who is in London, who you will see soon on the screen. Wolf is a member of ARB-DB Chambers and Managing Director of Global Resolution Services. Wolf was formerly European Legal Director and Assistant General Counsel at Northrop Grumman Corporation. And I'm also joined here in DC by Carlos José Valderrama, who is counsel at Sidley Austin, and who was formerly the president of the Government of Peru's Interagency Special Commission, representing the Republic of Peru in international investment disputes. Both speakers bring tremendous experience in investor-state dispute settlement from both a state and an investor perspective, and I very much look forward to hearing their thoughts today on investor-state mediation. Prior to starting their presentations, I will give a brief background on mediation in investor-state disputes and the services ICSID provides in this area. But before we begin, I wanted to go over a few ground rules and hand this over to my colleague Damon.
Great. Thank you so much. Hello, everybody, and good morning. We're a large group today, and this is the first time that we've been using this particular software for a webinar, so please bear with us if we run into some technical glitches. By default, all participants are on mute. We ask that you do not unmute yourself. However, we do invite questions. I'd mentioned just a couple minutes ago that on the upper right-hand side of your screen, you'll see a chat icon. If you click on that, that will open a chat board on the bottom right-hand of your screen. Please send us questions at any point during the event. We will get to those following the presentations. Please send those to me, Damon Viss-Dunbar. You can scroll down and see my name. As opposed to everybody, I will collect those. And again, we will get to as many as possible before the end of the webinar. We do have some IT support on hand if you run into technical difficulties. The number to call is +1 202 458 4336. I will type that into the chat box as well so you have it handy, and they are on hand to run through any audio or other issues that you might have. With that, I will hand it back to Frauke.
Thank you, Damon. To start with a framework for mediation in ISDS, in the ISDS area, of course we have the well-known arbitration route, conciliation, also under the ICSID rules, under the convention and additional facility, negotiation, fact-finding, also under the additional facility, and our topic today is mediation. Evolution of mediation in treaties. Recent international investment agreements incorporate references to mediation or conciliation as a form of ISDS. Either a specific reference during the amicable settlement period, the cooling off period as often referred to, or also as a standalone mechanism, possibly alongside arbitration. Examples of such treaties in the ECT provides for conciliation. Wolf will touch upon that in his presentation and offers also under the cooling off period options for mediation. Then the EU recent treaties concluded by the EU, the CETA or the EU-Singapore Treaty. Then we also have the ASEAN, CAFTA, and COMESA. You see, it is regionally diverse, that mediation is on the policy minds of states.
It's this WebEx is choppy.
If we look at arbitration cases, so settlement in practice, we see that over 1/3 of cases at ICSID, this is data based on ICSID arbitration cases, are frequently settled. Over 1/3 of these cases are settled or otherwise discontinued prior to a ruling by a tribunal. So what I want us to do is to open up the conversation about mediation. Mediation is not only a tool, as the practice has shown and as the policy has also shown us, to be used prior to instituting formal ISDS proceeding. This is not only for the cooling off period or the amicable settlement period, but may also be used during an ongoing arbitration and at different stages of the arbitration. Or we have also seen this in practice, that there has been a settlement by the parties after an award has been rendered. And as mentioned before, it doesn't need to be in the shadow of arbitration, but it can also be pursued as a standalone process. The community has been doing a lot on mediation in ISDS. As you see on the screen now, we have the work of the IBA committee developing the investor-state mediation rules in 2012, the ECT guide on investment mediation from 2016. Wolf will also touch upon this, and this is, I really want to highlight that document. It is very useful to get an overview of mediation in investor-state dispute area. And then the IMI's work on the competency criteria for investor-state mediators is a helpful document to understand what competencies a mediator might be helpful to have in order to successfully serve in the investor-state disputes area. What does ICSID do? ICSID offers support to mediation proceedings upon party request. We certainly have our dedicated staff team available with the experience in investor-state dispute settlement. We're here to facilitate communication between parties or manage financial aspects of the procedure. We provide our logistical support and offer our facilities for sessions around the globe. We can help parties in identifying qualified mediators and provide any other services the parties may request. One point I would like to highlight here is our recently launched investor-state mediation webpage, which is available in English, French, and Spanish. You can access it on the ICSID website under Process in the drop-down. We provide an overview of mediation, a very short one. On the bottom, we have information on the trainings that we have done and provide video interviews with people who you may know who have been very active in the field. And on the right side, we provide links to the related content, documents that might be of use to our users, and the upcoming events in this area. And those I would like to highlight for you. In May, on May 2nd, ICSID will participate in a conference on ISDS and the development on investor-state mediation. On May 7 to 10 in Paris, we will hold our second investor-state mediator training, and the first of these was held in June 2017 here in DC. This time, for the 2018 event, we have opened it up not only to experienced mediators and government officials, but also to ISDS practitioners without specific background in mediation. We will provide for those practitioners who do not have extensive mediation background and introductions to the knowledge and skills on mediation. So information for the registration will be up on the ICSID website later today, and I certainly invite you to consider registering for the event. On May 11, the same week, also in Paris, ICSID will be hosting our annual ECT conference. And there will be a panel on settlement of investment disputes without tribunal ruling. I highlight that panel because that is relevant to what we discussed today. Obviously, we think that the conference has many other interesting panels to offer as well. Last but not least, our mediation webinar series, which we are starting, we have a commemoration, or then the inauguration today. The next webinar series, we are intending to cover for the IBA about the IBA investor state mediation rules and a mediation insight. However, suggestions are welcome, and we would like to hear from you what you would like us to cover in those mediation webinars. So please do get in touch, and we would welcome that. So with that, I hand over to today's speakers. We will start with Wolf von Kumberg, and we will get him on the line.
Thank you very much. Thank you very much, Frau. I hope I can be heard. Am I heard? Yes, we can. Can you hear me?
Yes, we can hear you now. Thank you.
Excellent. Okay, very, very good. Well, thank you very much for asking me to speak today. I think this is a very interesting development, actually, in ISDS. Because we're looking at a tool that will allow investors and states to perhaps deal with disputes, as Frauke said, at a much earlier stage than before the arbitration itself. And myself, I've spent almost 30 years working for several global companies that invested probably in 40 or 50 different states worldwide. And I've seen actually the issues that develop with investments. And often I look back on it and I say that there would have been better ways of resolving these disputes than having to litigate or arbitrate them. And that's why I really feel very positive about this development, because I think, interestingly enough, states, in fact, are very interested in finding other mechanisms to deal with their disputes other than the traditional arbitration route. So I very much welcome this opportunity to speak today. Perhaps if we go on to the next slide. So as Frauke said, the ECT and the ECT Secretariat actually has taken a very active role in trying to promote mediation, at least within the Energy Charter Treaty. A few years ago, we were approached as IMI, the International Mediation Institute, to work with the Energy Charter Secretariat to put together a mediation guide. And the Secretariat's interest here was really to find a mechanism to deal with conciliation within the treaty. The treaty has a reference to conciliation, which is an option that an investor can take up. However, there was nothing within the treaty to describe what conciliation was, nor what, in fact, the conciliation process would look like. And so together with a number of other institutions, including ICSID, we started to look at putting together a helpful guideline for investors and states in the event they had a dispute under the ECT. So really, what the guideline is meant to be is exactly what it says. It's a guide. It's not something that is mandatory. And that was something that was discussed, and it was decided that it should be left up to the parties to decide whether they wanted to institute mediation, in particular the investor, to make that decision. Next slide, please. So as I said, really the purpose for the guide was to explain the mediation process in general. And as I'm sure all of you know, mediation, of course, is not an adjudicative process. A mediator does not render a decision. A mediator probably won't even render an opinion, but what a mediator will do is try to bring the parties together by using various techniques in order to reach a settlement of all or some of the issues that the parties have. So that's an important point. You may deal with some of the issues, and some other issues might go on to arbitration, but that, of course, already helps with the process. The guide explains the role of the Energy Charter Secretariat as well in helping to facilitate disputes. And really, it's meant to be educative as well for both states and investors as to how the mediation process works and what they should do to actually prepare for mediation. Next slide. So as I said, the guide is really a procedural framework. And by the way, you can find the guide at energycharter.org. So energycharter.org, if you go to that site, you'll then see another link to their settlement system. And if you go to that, then you'll also find the guide. So the guide goes on then to set out the steps by which mediation can be used. And in particular, it highlights some of the obstacles. And this is really one of the other things we'll discuss today is the obstacles that really states have in order to effectively mediate. Business-to-business commercial mediation has been around for quite some time now. Many larger, more sophisticated companies are very familiar with the mediation process. In certain states, mediation is practically mandatory before you can go to court, so that investors largely, and certainly their legal counsel, are very familiar with mediation. It's really states that have more issues with the mediation process itself, and we'll look at some of those issues, but that's what the guide also tries to address. It then also sets out the role of the participating institutions under the treaty, so whether it be the ICC or ICSID or the Stockholm Chamber, it tries to identify how those institutions can also help then with mediation. Next slide. So really, in order to help promote the use of mediation, as Frauke has already pointed out, there's a role really for all of the participants in the ISDS community. And that includes, of course, the states. And one of the things that states have to do is really put a process, an internal process in place, which allows them to mediate. And we'll get a little bit into more detail on that in a few minutes. Institutions such as ICSID have a role to play, and ICSID is playing, I think, a very large role in order to try to at least focus on the benefits of mediation and how mediation might be used within the ICSID framework. Other institutions such as IMI are working not only on the ECT guide itself, but we've gone on now to look at the criteria for investor-state mediators, as Frauke said, and really the idea behind having criteria for investor-state mediators is to allow training organizations to train investor-state mediators so that there are available to states and investors a cadre of people who can actually mediate disputes such as this. Given that states and mediating with states is different than typical commercial mediation, mediators do have to be specifically trained to deal with some of the obstacles that exist in state mediation. Then in addition to that, there will also be a standard that is published by IMI with respect to investor-state mediation, probably sometime in 2018. Then there's also clearly a role for the investor. I mean, the investor makes a determination, certainly under the ECT, whether it desires to mediate. So it's something, obviously, that investors themselves then have to be familiar with. Their counsel have to be familiar with mediation and make a determination whether mediation might be something that is useful in that particular dispute. Next slide. So we talked a little bit about obstacles, and this is really the key to making a success of mediation in these types of disputes. I recall speaking probably 5 years ago at a conference about the potential for investor-state mediation, and I was told by many of the participants that it would never work because there are just too many obstacles to states mediating. Just from my own experience, I know that, I mean, there are many obstacles in even having settlement discussions with states, because states and the way they operate, of course, is very different than the way a commercial enterprise operates. And so what you really have to do is you have to dissect the issues that the state has with respect to mediating, and you have to see how you can address those obstacles in order to permit states to mediate. And we know states mediate. In my own experience, we had a number of disputes where we had to deal with arbitration, but then we found a mechanism whereby we could bring mediation into the framework and actually utilize mediation to reach a settlement with a state authority. So it is possible to do that, and certainly on commercial type disputes, many states and state organizations do have a mechanism in order to mediate. So it's not something that is unheard of, but it is important that there is a procedure put in place. In particular, where there are large bureaucracies involved, and we know in certain states there's a question about accountability and transparency, and state officials are often concerned about their own positions, not only when they're mediating, but also in settling a dispute, and whether they might be called to account for that settlement. And we know there are cases of that nature where state officials have faced prosecution. So that is certainly a very important element that has to be addressed. Next slide, please. We also know that the motivation for states to make decisions is perhaps different in certain ways from the way a commercial enterprise will decide whether it settles a matter. Commercial enterprises, of course, have their own stakeholders that they're responsible to, but often if a settlement makes commercial sense, then of course the executives in the company will decide to settle, and they have the authority then to decide to settle. Whereas we know that when a state makes a decision, it's often public policy and politics that have to be taken into consideration with respect to making that decision. And who actually makes that decision is often unclear. And so that's something that certainly has to be clarified with respect to any kind of mediated settlement. So often there are different objectives for the state and the investor, and trying to get those rounded is often very difficult. So again, in a mediation situation where a neutral mediator is brought in to deal with the state and the investor, that mediator will have to understand that the objectives of those parties are going to be very different, and that very different issues will have to be addressed before a settlement can be reached. So that's an important element here. It's often also the case that by the time arbitration is reached under a BIT, there have already been a lot of negotiations that have taken place, because by that's really the last element in the dispute. By the time it reaches that stage, the parties will already have been trying to resolve whatever that issue or issues that may have arisen are. So again, at that point in time, it may be very difficult to mediate. So if you leave it to the cooling off period, which exists in many of the BITs, and utilize that for mediation, by that time, it may be very difficult to do so. Then, of course, there are cultural issues, and the media plays a large role in a lot of these different types of disputes. There are communities that are often involved. And so the framework for a dispute with the state is, of course, much more complex and difficult to deal with than a typical commercial dispute. Next slide. So what we have to do in starting to address this issue, and it's what the ECT has really tried to do in its guideline, and then in trying to work with states after its guide came out, is to help states to incorporate a mediation procedure in their own domestic process. The IMI is actually working with the ECT right now to see if they can come up with a template protocol that can be implemented by states. And there are already several states that have been putting a protocol in place, trying to deal with the various obstacles that we were just discussing in that internal process. As we know, mediation is an interest-based process, and what it tries to do is to get the parties to look at their interests rather than simply their legal rights, and see if an accommodation can be reached between them by trying to do that. So I guess the point here is that simply because negotiations between the parties, which are very much right-based negotiations normally, doesn't imply that mediation can't work. And I think, again, going back to what Frauke said, I mean, mediation can really be used at different stages in the process. And mediation, I think, if it's better understood, and where states already have or begin to have a culture of mediating disputes, they can be dealt with much earlier than in the arbitral process, or just before the arbitral process. So that's something certainly that should be kept in mind. Of course, mediation can be used in that cooling off period, because the intent of that is, although it's not often used, for the parties to see if they can't reach a resolution. And in fact, mediation can also be used after an award, because it may be that the resolution of the matter through the award itself isn't necessarily a solution either, but rather by mediating how that award is actually going to be recognized, that might be a better resolution of the matter. So mediation can even be used at that stage. So as we said, institutions such as ICSID and ECT and ICC are certainly encouraging the use of mediation within their own procedures. And I think given that there are a lot of complexities with respect to investor-state disputes, and particularly because often communities are involved in those disputes, because they've been harmed in some manner, or at least there's an allegation they've been harmed in some manner by the investor. What mediation allows is actually more stakeholders to be involved in the resolution of the dispute, because it's not just strictly the parties to the dispute that can be party to the mediation. The mediation can be much broader than that. It can bring in other strictly non-official parties to the dispute can be part of the mediation process, and other matters that are not perhaps strictly within the four corners of the dispute can also be discussed and maybe form part of the resolution of the dispute within mediation. So mediation is extremely flexible, much more flexible certainly than the arbitral process. Next slide. So as we've already said, I mean, when you use mediation earlier in the dispute cycle, it helps also to preserve relationships. So if you do it early enough, and if it's a type of situation where the investment might in fact still continue and the relationship can be preserved, or maybe the investment continues in a different form, but it allows the parties to have a forum within which to discuss altering that investment rather than perhaps within a strictly legal forum. The other point, of course, is, and one of the important things with having BITs is that there's a mechanism within the BIT to resolve disputes, which is an important factor. I mean, rule of law, as we know, is extremely important to investors. Investors will usually only invest in an environment where they feel they have a credible dispute resolution system. So that's an important element also of having mediation as part of the process, because it is a credible way of resolving disputes. And then, as we already said, in training mediators for this type of dispute, that will add transparency and legitimacy to the process as well. Next slide. So we touched very briefly on the benefits to investors. As I said, most investors, and certainly their counsel, will have had exposure to mediation and understand the benefits that mediation can bring. And so it's probably less a matter of convincing investors to mediate than states to mediate. But of course, as I already said, the benefits for mediation to an investor can be significant simply because they can try to resolve the dispute much earlier in the dispute cycle than through arbitration. Mediation is also relatively inexpensive compared, of course, to arbitration or litigation. And it can be relatively fast and efficient, particularly from a business perspective, which is the one really I'm coming from. It relieves management of a burden and business resources that have to be put into, as we know, the preparation of significant arbitration or litigation. I mean, that takes a lot of company time and resources. So that's something, if you can resolve a matter earlier, certainly is a big benefit. Businesses generally are already familiar with mediation, so it's not really a foreign concept to them. Very important, I think, both for investors and states, and it's often overlooked, is the fact that if they can control the settlement that comes out of a mediation, that's much preferable than to have an arbitral tribunal or a court actually render a decision, because as we all know, there is no case that is 100% in anyone's favor, and we're never sure how a matter will be resolved by an arbitral tribunal. And if the parties themselves have a mechanism to try to reach agreement, no matter how bad that agreement might seem, it's still an agreement that they have determined, and it often leads to a much better result. As we already said, relationships can be preserved, and perhaps in some cases, the investment itself can be preserved or perhaps altered in some fashion that's amenable to both parties. And as we said, we can resolve, or we can bring into the mediation, a lot of parties or other non-direct parties to the dispute, which might help to deal with a larger problem that rather than just the dispute itself. All right, next slide. So this is just to recap what is really necessary for us to be able to make mediation part of the ISDS process. And that's establishing criteria for IS mediators, which is something that IMI is currently working on. The internal protocols and procedures, which again is something that the ECT and IMI are currently working on. And then just some of the process issues, ensuring that all the stakeholders are involved in the mediation process itself, ensuring that the state officials that are involved in the mediation are properly authorized and empowered to be able to reach a settlement. Next slide. Internally, again, ensuring that the local law permits the public administration to mediate. And a very important point that it protects public officials from retaliation if a settlement is reached. Enforcement is, of course, always an issue, but what we're looking at here really, and UNCITRAL is currently looking at in one of their sessions the enforcement of mediated settlements. So that is something that is currently being looked at. We don't know what the result of that will be yet, but there's a potential that there is agreement with respect to mediated settlements. And then the last thing is more transparency in the process. We're already seeing that in arbitration, of course, and in commercial mediations. What we're really looking at here is that public policy concerns are addressed, and that mediations perhaps are not as private as they would be in a business-to-business situation, but rather that there are mechanisms in place for the public to also understand what has occurred within the mediation, and if a settlement is reached, that the settlement in some form is also then made public. All right. Well, thank you very much.
Thank you very much, Wolf, for this interesting presentation from the investor's perspective. As Damon has said at the beginning, we will group other questions, and thank you for keep sending them in. We are starting to have them here. We will address them all after Carlos' presentation, Carlos José's presentation, I should add, which we start then now. Over to you.
Many thanks, Frauke, Wolf, Damon, and colleagues. As usual, I will speak based on my personal experience on the matter. Investor-state dispute resolution, ISDS, is widely debated in various settings where some support the idea that it is approaching to its end. Whether or not this is true, one thing is clear. Today, most of the funds available for states to implement development projects in many areas come from private investors. In order to develop infrastructure and other projects of public interest, states enter into concession contracts, stability agreements, bilateral treaties, and also produce various regulations to protect this private capital. This table shows the evolution of foreign direct investment, in red, FDI, and official development assistance, ODA, in green, which comes basically from multilateral development organizations, both compared to global GDP, in blue, clearly illustrating the growing presence of private investment in the world economy and a dropping presence of ODA, giving us a light on how states may be funding themselves. Mediation as ISDS. Even though mediation benefits and advantages are evident, since allows to the parties involved in a dispute to solve the dispute in the most direct and efficient manner without need to enter into an adversarial mode and clearly reduce costs and time. To date, mediation is not yet a common ISDS mechanism. If it were, the ISDS discussion would focus on mediation instead of arbitration, but that is not the case. Treaties like DR-CAFTA and the new CPTPP treat mediation as a mechanism to be considered as a tool for the cooling-off period. Even though mediation is not included in most agreements, my understanding is that in any case, there is no obstacle for parties in an investor-state dispute to agree on a system negotiation. I personally suggested this to a couple of investors when working for the government, unfortunately with no luck. Assisted negotiation can be used in 3 moments. When the dispute is starting, but it is not properly international in character, since formal triggers have not been activated yet, during the formal consultations or cooling-off period, and during the adversarial phase of the dispute. I find the first one to be the most effective since it allows more flexibility and confidentiality to the parties. In my experience, aware of the imminent dispute, our job was to approach the relevant public entity, understand the dispute, and prepare a report explaining the specific risks of taking that dispute to the international arena. Risks like high costs or being bound by a public award that reveals the mistakes and errors committed by the state and that can be used against it in the future. This gave the support required by the entity directly involved in the dispute to reach an agreement based on our report and recommendation. Next, during the cooling-off period, engaging in negotiation is vital for the state. Many times, state representatives are reluctant to take advantage of this mechanism, but that will be a big mistake. A direct management of the negotiation phase is very important for the state, allowing it to solve the dispute. Or, on the other hand, clearly identify the investor, its background, its attorneys, assets, liabilities, and the scope of the potential claims, allowing the state to determine the best course of action. The state failure to fully develop and take advantage of this stage could lead to problems during or post the arbitration phase, such as the claimant's failure to issue payment for costs. Many state representatives complain about this. But, well, the negotiation period has arisen. If correctly used, this stage is very useful for the defense of the state. It is the best time to collect, identify, and organize documents, communications, and witnesses, prepare and adjust its position in relation to the disputed claims, and work on possible defenses. We developed a standard model for meetings, for negotiation meetings, formally inviting the investor and its attorneys to explain their claims. We provided them with the time and tools needed to present their case, followed by a round of questions, finally signing the minutes of the meeting. This proved to be very useful. First, the investor found an office ready to effectively listen to its claims, giving parties a second wind on relation to the dispute. As Wolf mentioned earlier, relations at this point are tarnished if the office of representing the state effectively focus on the dispute and really pays attention to the investor, the investor will, the relations will not be that tarnished anymore. Second, allowing the investor's attorney to attend to the meeting gave the investor certain feeling of protection. As a result, the Commission had a much better idea of the details of the dispute and an investor's position, and therefore was better equipped to make informed decisions. If negotiations were successful, settlement documentation was reported to and subsequently approved by the President and his Council of Ministers, finally signed. This is particularly important because it is through this mechanism that the head of the executive power assumed the responsibility of the outcome of the negotiation. We had powers to reach the text of the agreement, but not to bind the state. I can't imagine how difficult for state representatives would be to receive an arbitration notice and knowing that prompt action has to be taken are not sufficiently prepared to face a dispute. Mediating once the arbitration or litigation phases have started tend to be easier, this is in my opinion, since the party who may lose the dispute usually proposes it, and its main concern is to finish with the dispute as soon as possible. The cons of mediation. Problems with mediation may not arise because of the process itself, but because of the challenge to conciliate, to bring together this legal feature with the state public formalities and particularities. If arbitration as a form of ISDS mechanism is currently being severely criticized, if not implemented carefully, mediation may not have a better luck. Criticism seems to be originated in the natural distrust the public opinion has towards the relation between public entities or officials and private investors. The public requests publicity and clarity in order to understand what the business's interests and rights demanded are. While efforts to reform ISDS are currently displayed, mediation offers a new formula, an alternative to arbitration that appears to be prima facie more efficient in cost and time. However, this alternative relies also heavily on confidentiality. Two parties looking to solve a complex dispute through mediation may need calm and discipline to focus on the disputed issues, the proposals of the counterparty, and the goods and rights they are prepared to bargain. If the mediation process becomes public and public voices are able to speak while negotiating, then political interests may arise. Different stakeholders may claim discrimination against them. Criticism will be made in real time, and the damage will be made not only to the negotiation process, but to the position of the states and the parties in the future litigation or arbitration. Last year, a team of the Center for International Law of the National University of Singapore, led by Professors Christopher Thomas and Lucy Reed, released a very interesting study, concluding that the state is the party more reluctant to settle a dispute, mostly because of fear to criticism, prosecution for corruption, and setting a precedent, preferring to defer the responsibility for the decision-making to a tribunal. I must agree with her conclusion. In my opinion, many state representatives at all the levels of government are hesitant to assume that responsibility. Instead, the less controversial course of action is to bring the dispute before an arbitral tribunal, let the tribunal make the decision, and then comply with that decision, avoiding personal responsibility. What to do? How to solve these problems, in my humble opinion. Different international organizations and other entities are working hard to find different remedies to the apparent crisis ISDS is experiencing. From new treaty models, transparency rules, centralized appellate courts, ethical rules for arbitrators and counsels, promotion of conciliation and mediation, including a draft convention of its enforcement, to a whole reform of the system led by UNCITRAL. But independently to all of those external variables, states need to be internally fit to face ISDS, however it develops or evolves. Creating an office to efficiently represent them in ISDS processes while providing protection and securities to their public servants and representatives should be a priority of the states. For states. In my experience, when an investor-state dispute initiates or threatens to initiate, representation of the state must be exclusive. Any other official or authority must, by order of the law, refrain to get involved in any negotiation or discussion related to the dispute. Otherwise, the state may fall into contradictory statements that will be used against it, weakening its position. This exclusivity can be secured by granting the representative's office with the power to declare its own competence. If assumed, on contrary, by mandate of other authority, it then will lose that exclusivity. By being capable to assess the conditions of the dispute and then assume its own competence, the defense office obtains plain authority over the dispute. By this, the state acknowledges the case and its risks, or the dispute and its risks. If it's a winning or a losing case, potential costs of the dispute, the award and its interests, the potential findings, conclusions, and statements a tribunal may consider in an award, and its consequences. Powers to negotiate in representation of the state must be expressly stated in a law. State representatives, when negotiating in the name of the state, comply with that law. Peru is represented by a commission involving the relevant public entities, making the representation transversal to the state, simplifying the coordination of the defense and granting a sole uniform position towards the dispute. Other considerations. In order to use mediation as an ISDS mechanism, states may think about certain things like internally agree to its use and the use of model provisions in treaties and public contracts. Thus, the internal discussion about the convenience of mediation or not is made at this point, not when the dispute is being settled. If the treaty or the contract includes mediation as a mechanism to resolve disputes, then state representatives will use it. Second, decide on the type of dispute this mechanism is set for. It is possible that not every investor-state dispute would be apt to be settled by mediation. Most probably, it will work better for contract disputes, licenses, and particular decrees. But general rulings like land regimes or natural resources may be more difficult, since general interests or other stakeholders could be affected. Employ the services of a well-reputed institution with highly professional and experienced mediators, or list of mediators, in order to grant assurances of rectitude to the public opinion, considering that it is highly probable that the process will be confidential. Reputation is always a key element. Also, allowing the parties to get the most advantage of the mediator's recommendations, which is something state representatives could use to support their strategic decisions. In comparison to other mechanisms as arbitration, mediation appears to be a faster procedure but may need more internal discussion than arbitration. It would be advisable to have a centralized office to effectively manage this internal consensus. Next, Draft a basic and flexible set of rules of engagement into mediation, like good faith, without prejudice, confidentiality, joint public statements if applicable, deadlines, and bar of future incriminatory use of representations made during the negotiations. Granting the representation office with powers to negotiate until reaching a final draft, but ex post express authority to engage the state into an agreement. In our experience, that formula proved to be very helpful. Finally, always maintain a focus on the goal, obtaining a clear, express, and written withdrawal of the claim, and a statement from the investor that he is satisfied with that negotiated agreement. The written agreement should also prohibit the investor from bringing the same claim in any other forum. Having said this, I finish my presentation by giving thanks again to my colleagues and looking forward to expand it during the questions and answer period. Thank you very much.
Thank you very much, Carlos Jose, for that very interesting overview, and I'm very grateful to both you and Wolf for sharing your practical experience within the government or within a commercial setting of how mediation can actually work. I'm grateful to our audience who has been sending in questions, and I think this is really fantastic to make this lively, and maybe this even encourages people to participate who in a big conference setting may not be standing up and sharing their thoughts with us. I start out with a question for Wolf, which is, I have a question for Mr. Kumberg. How are the difficulties faced by states in mediation different from those in arbitration? And maybe Wolf can start with a question first, and then we hand over to Carlos Jose.
Certainly.
All right, well, that's actually a good question. And I think Carlos actually answered much of that in his discussion, because the problem for most states, and that's a problem that's universal, I think, it doesn't matter which country we're talking about, is that the person who is involved in actually having to deal with the dispute and potentially with the resolution of the dispute, be it through negotiations or through mediation, has to actually take responsibility, particularly if they're deciding that they have to, or that they'd like to resolve it through a settlement. Whereas, of course, through arbitration, somebody else will make a determination. In this case, the tribunal will render an award. Whether the state is happy with that award or not, there will be a requirement for that award to be complied with. It's much easier in any kind of bureaucracy for then the state official to simply wait until there's an arbitral award and then comply with the award, rather than having to make a decision as to whether there is a settlement opportunity and then to settle the matter. As I think Carlos has very well pointed out, there has to be an official process put in place that the state official can then comply with, and thereby protect themselves from any kind of criticism later on. And so if mediation and just as also a settlement process is put in place within the state that can be followed and can be demonstrated that it has been followed, then that would make it much easier for mediation to take place.
The same question. Do you have something to add, Carlos Jose?
No, I think Wolf was very clear with his answer. Thank you very much.
We have one other question that goes in the same direction. I think the presentation touched upon that, but Wolf and Carlos Jose, maybe you could go back. Would the state be more willing to mediate in order to maintain working relations within the home country, especially when the investment is insured by a public insurer? Carlos Jose, would you like to start?
Certainly. Can you repeat the question, please?
Would
the state be more willing to mediate in order to maintain working relations with the home country, especially when the investment is insured by a public insurer? Well, in general terms, I can say that the state will be more willing to settle a dispute for many reasons. Of course, among them to maintain its good relations with its peer, the home country of the investment. But I don't find that that will be for any specific reason. It's just in general terms. It's important for the state.
Mm-hmm.
Interesting.
I think maybe just to add to what Carlos Jose said, I think if in any dispute, and any dispute that I've seen, if there's still the potential for a relationship, then it's much easier to resolve that dispute than where the parties simply will no longer have a relationship in the future, and really all we're talking about then is the compensation with respect to that particular dispute. That becomes much harder then, because then we're not dealing with other factors. And so if there's still a relationship that can be salvaged, if there is still an interest within the state for that investment to continue in some form, and for the investor also the investor is interested in that, then of course there may be mechanisms to reach a settlement. It'll be much easier to do so.
Mm.
Yes, I've been trying to express this for a long time, and in my opinion, ISDS by itself, no matter what kind of mechanism it involves, as mediation or arbitration, but in general terms, ISDS improves the bilateral relations, because what ISDS does is it separates the private interest of the investor and puts it apart from the public relation between the states. The home state, since ISDS exists, the home state has no need to protect its investment or its investors. So public interest among states maintain clear.
And you've seen that in practice.
Yes, a few times, yes.
Another question relates to the stakeholders, and that was one piece that we really discussed in our investor-state mediator training last year. How to put all the representatives of the parties concerned around the investor-state mediation table. How to deal with the legitimacy of their mandates. Maybe that is two parts to the questions, the stakeholder and the legitimacy question. Wolf, would you like to start with the stakeholders?
Yes, I mean, as I said in my presentation, I mean, one of the advantages of mediation is that you can bring various stakeholders into the discussion, and they're not necessarily a party to or an official party to the dispute. And I think in the framework of investor-state, that, of course, has many potential advantages. Of course, it's also fraught with a lot of difficulty, because what we're talking about then is bringing into the discussion perhaps communities or organizations that politically will be difficult for the state to include. The other difficulty is who actually speaks for that organization, or in particular for the community, and what legitimacy do they have. And as we discussed, I think, in the training that we did in Washington, one of the key elements of investor-state mediation is the work that will have to take place before the mediation actually takes place, and that is putting the framework for the mediation together and having that discussion between the parties early on as to who actually should participate in the mediation. And of course, that is always within the control of the parties. I mean, the mediator will attempt to highlight perhaps other stakeholders that should be present, but only the parties themselves can agree that that party should then be present at the mediation. So the parties never lose control of what's actually going to happen. But if the parties can agree, for example, that a particular community also be part of the mediation, then they can set a framework around that participation. Who is it that will attend? What is it that they will actually be permitted to do within the mediation? And what might some of the outcomes be with respect to the representations made by that party. So the framework is extremely important to be established before the mediation, but I see the potential, at least, for third parties to be involved.
Thank you, Wolf. Carlos Jose, would you like to add on the stakeholder and the legitimacy question?
Sure. In my experience, I think that in order to put all the representatives of the parties concerned in this investor-state mediation table, what we did is the Peruvian structure for defense on ISDS disputes or investor-state disputes allows the state to have a two-tier structure. Since the dispute is related only between the investor and the state, I would keep that table between the state and the investor, and on a different stage, on a previous stage, on an internal stage, I would include all of the other parties. Let's say, for example, local communities representatives. They are usually the most difficult to deal with, and if I bring them to the negotiation table, that may threaten the negotiation. I preferred to first deal with them, understand their needs, understand their position in relation to the dispute, and assume their representation when sitting with the investor to negotiate the solution of the dispute.
So you mean the local communities can enter the process, but on the side of the state, and then
Yes.
the state enters into the mediation with the investor?
Yes, with having previously understand what is the community's need.
Mm-hmm. This leads us, it's a perfect segue to the next question, which is, do the mediation rules allow affected local communities to participate as parties to the mediation process? And how would the cost of these communities be covered? Wolf, I know, again, referencing our training from our mock piece involving the local community leaders, that was an aspect that we tried to practice. Would you like to share some thoughts on that?
Yes, I think when it comes to rules, as we say, the mediation rules, generally, and if we could just point to the IBA rules, for example, on mediating investor-state disputes, which are a good set of rules that could be incorporated. The rules generally only set a framework for the mediation, how the mediation process will be commenced, and then how the mediator generally might deal with the mediation. But really the decisions as to the parties that will have a voice within the mediation is left up to the mediator and the parties themselves, the parties to the dispute themselves. And whether or not, a community, for example, or an NGO could be brought into the mediation sphere. And I like very much what Carlos Jose said, that maybe you've got a two-tier system, and these other parties have a means of making a presentation, but they don't actually, and certainly are not involved in the actual negotiation of a potential settlement. So you separate the two. That's, I think, a great idea. But I think, again, who pays for it? It's going to be a decision for the parties sitting down, so the parties to the dispute sitting down with the mediator at the outset when they're putting together the framework for the mediation to decide who is going to attend, who's going to pay for their attendance. Will it be the investor? Will it be the state? And in what forum will they actually be able to participate? So I think, again, it's not the rules. I mean, none of the mediation rules will actually deal with that. The procedural aspects will be decided by the mediator together with the parties, the official parties to the dispute.
Nothing to add. I agree with
Maybe that is one just to highlight here about the flexibility of the process to tailor it to the disputing parties and to affected communities. We're not talking about a non-disputing party participation as we have them under the ICSID rules, where there are very clear framework who can submit a written submission or access, have other access to case records or hearings. One piece of that, we get more into the legal questions. We have a couple of those, and one of the questions is whether ICSID or other international institutions for arbitration use arbitration for PPP investments. Carlos Jose, would you like to start?
Certainly. Well, this is about mediation, so I'm going to speak about ISDS, regardless of the formula or the mechanism. Is ICSID or other international institutions for arbitration for PPP investors? Yes, in fact, in our experience, I may say maybe half our cases, maybe a little bit less than half.
Peru's cases?
Peru's cases, yes, have been originated under contract provisions. And we attended those cases coming from contracts. The interesting thing about this question is that, and our experience on particular to this subject, is that the good thing about having these provisions in contracts, different from treaties, is that in contracts, the provision goes both sides. So then is when the state can bring a claim against the investor on the international arena. We've done it. In fact, in our experience with mediation during arbitration processes, occurred because we, as Peru, as the state, we brought a claim against an investor, and it was a clear claim in favor of Peru. So the investor knocked our door, and we reached an agreement, which was very favorable for the state. So, of course, it's good to use it for PPP investments, no doubt in my mind.
Well, would you like to add something?
Yes, I think just perhaps as an example and following up what Carlos Jose says, one experience that we had, and I mean, I'm careful because with respect to settlements, of course, they are confidential, and so I can't really talk about it in detail, but we did have a dispute with the government of Egypt. Again, as Carlos Jose said, this was based on our contract, and our disputes clause within that contract had an arbitration clause, but it also had a provision for us to attempt an amicable settlement before arbitration. And in that case, the arbitration was actually commenced, but we did actually bring in a third-party neutral in that case to try to resolve the dispute. There were counterclaims. There was a claim for payment by us and a counterclaim by the government of Egypt in that case. And we did actually, this is one of the examples that I can give where mediation was actually successful in resolving that particular dispute. So it actually never did go then to arbitration.
From our end, I can say that the ICSID works together with the IFC for model clauses for PPP agreements, and many of them have an ICSID arbitration clause, which then links to the mediation piece, and maybe that is one thing that would be helpful to clarify. There is a perception or an understanding that Article 26 of the ICSID Convention, the so-called exclusivity rule, prevents mediation to be conducted in parallel of an ICSID arbitration that's ongoing. And if you read that rule carefully, you will see that the drafters of the convention established a presumption in favor of exclusivity for ICSID arbitration. They had local proceedings, local court proceedings in mind. However, unless the parties state otherwise. So if the parties have a clear consent to another remedy, that is possible under Article 26. And that leads us to the next question. It's a little long, so bear with me. How would the inclusion of a mediation or assisted settlement clause in a concession agreement, for example, operate in light of an ICSID arbitration clause in a BIT? There have been instances where tribunals have ruled that waiver of jurisdiction and concession agreements do not remove the jurisdiction of an arbitral tribunal at the international level. So go back to how would the inclusion of a mediation or assisted settlement clause in a concession operate in light of an ICSID arbitration clause in a BIT? And maybe to start with, to separate, assuming that the arbitration is brought on the basis of the BIT to ICSID, you would check obviously the wording in the BIT for cooling off requirements for mediation, whether mediation is possible, like under CETA, as a standalone process or in parallel. Again, the piece on Article 26 I wanted to highlight before. Carlos Jose, do you have comments on this question?
No, I agree with you. I will need to read the terms of the BIT and use the BIT for cooling off period.
Or otherwise, under the concession contracts, should the arbitration be initiated, assuming the concession agreement has also an ICSID clause and has an inclusion for mediation? That is what you explained to us a few minutes ago.
Yes.
Wolf, would you like to comment?
You know, I think what you're saying makes a lot of sense. I think our agreement, such as a concession agreement, as a provision, and maybe in this case an express provision, that there be mediation before arbitration. And I guess the question is, do you actually have to comply with that under the BIT? And presumably you don't. But I think what it does do, it gives the parties an opportunity to choose to mediate without actually making a concession by mediating. So what I'm saying there is, if you have no mediation provision anywhere, then, you know, in order to mediate, parties have to agree to mediate. And I think, as Carlos Jose said earlier on, sometimes the weaker party asks for the mediation, and it's a sign of weakness, and I think people see it that way. If there's a provision to mediate, it makes it a lot easier because you can say, there's a provision to mediate, let's just try to mediate. It makes it easier for both parties, actually, particularly the state, perhaps, to mediate.
Thank you, Wolf. One framework question. Would it be possible to cite to one or two concrete examples of states having established internal mediation protocols and procedures and having modified domestic legislation in order to overcome impediments to investor-state arbitration? Well, from your experience at the IMI and your general work in this area, would you like to start? I'm happy to repeat the question if you like.
No. I understood the question, and I think to be fair, there are a number of states that have certainly on the back of the ECT guide now started to implement, at least internally, a procedure to allow them to mediate. And certainly, Frauke, we can probably get the information as to the states involved, so you can provide that in some fashion, perhaps, to the audience. So that certainly happened. I mean, my own experience here in the UK is that the British government has actually promoted mediation for a resolution of its commercial disputes. And certainly there's a mechanism in place within the British government to allow mediation to take place. And in fact, under the defense procurement guidelines, there is actually a provision for mediation. So I can say, in my own experience, that certainly there are states that have put provisions in place.
I can add to that from our member states that there is a large awareness among states for mediation as a successful procedure. States have told us that. I have one example in mind. They have settled 3/4 of their investment disputes prior to coming to ICSID arbitration and being, in that sense, publicly known. There is a difference. It depends on the internal organization of the state to what degree the internal protocols and procedures for mediation are formalized. There are a couple of states that have shared with us that less formalization works well within their way of organizing themselves, whereas others, such as Peru, has really benefited from a very clear structure of authority and which office is in charge and which procedures are to be followed. That is one sort of. I don't think there is a one-size-fits-all from what I have seen, at least from the member states' feedback we have gotten.
Yeah. Well, we develop our own model. It's not rocket science. It's just listen to the other party
and that is what we have seen exactly. We have seen states communicate how has it been working for you, and then they identify what could work well within their own government.
Yes, in fact, it's interesting because on a few arbitration notices, we received comment from investors stating that their good experience with the Commission. So yeah, it was very good.
Mm-hmm. Speaking of the authority and framework, we have one question. Could one of the speakers further address the issue of authority to settle the authority to settle of the state representatives, in particular if the dispute triggering event is an act of the state's legislative bodies? Is the possibility to mediate in the treaty sufficient? Let's first take the authority piece. Carlos Jose, would you like to start?
Certainly. Can you repeat?
Where is it?
Could one of the speakers further address the issue of authority to settle this of state representatives? Well, in our case, Peru is represented by a multi-sector commission that assumes the representation of the state before the dispute and the investor. And if there is room for negotiation, the commission negotiates in representation of the state. The commission reaches what it considers a satisfactory agreement text, and it turns to the Council of Ministers, explains the Council of Ministers about this transaction or this document, the settlement, and the Council of Ministers issues a resolution accepting the terms of the negotiation, and it then is when the Commission goes back to the table and signs in representation of the state, binding the state. That is our experience. I think it was very efficient, and if the Council of Ministers consider that negotiation or that solution was not agreeable for the state, well, we went back to the table telling the investor that unfortunately the state will take this case to an arbitration process, or try to find another agreement, right? Yeah.
Wolf, would you like to add something?
Well, I think, while in commercial mediation, the parties are encouraged, of course, to bring somebody to the negotiation with the authority to settle. The reality is that very few individuals who are negotiating ultimately have the authority to actually sign the settlement agreement. I mean, you could have a senior company representative who might have that authority, but it's not unusual then to ensure that you've got authority, and this certainly in this context will have to happen, authority to negotiate, as Carlos Jose says, but that there then has to be a ratifying step, and either the board of a company or the council of a state will have to then first ratify the negotiated document before it is actually signed. So having that two-step process is probably going to be quite common for investor-state mediation if that is to take place.
Thank you. A couple of questions that we have received concern the qualifications of the mediator. What do you think about the right profile of a mediator for investor-state dispute settlement cases? 1, train international arbitration specialists to have mediator skills? Or 2, train professional mediators to investor-state dispute resolution matters? That is indeed a question we have thought about a long time, and maybe Wolf, with the competency criteria work and your experience as a mediator, maybe you start with your thoughts.
Yeah, that's actually an excellent question. And in fact, in the IMI criteria, a lot of thought has actually gone into that. I think to have credibility and for the process to actually work, both the states and investors will have to have a trust in the individuals that are mediating these types of disputes. And what certainly for the state that will also mean is that they're familiar with the international investment process, with the financing mechanisms, with public international legal issues, and also international arbitration procedures under the various rules that exist, such as ICSID. So I think there will have to be certainly familiarity with all of that, simply for the mediator to be effective. But at the same time, clearly, there are mediation skills that a mediator will have to have, and the normal competency for mediators will also have to be applied. So I think to answer that question, it's a combination of both. It's a combination of having the expertise in this particular field, but then also having the general mediation skills.
Thank you. Carlos Jose, do you have thoughts?
Well, yeah, between training an international arbitration specialist to have mediator skills or a professional mediator to have IS skills, to be honest, I wouldn't tag people with being a specialist or something or not. For me, the skills are basically being a balanced person with certain that is capable to grant confidence to both parties, and from then develop the skills of the mediator. But if the person is an arbitrator or not, depends on the person.
It's a piece to be determined by the specific parties who they think would be most helpful in assisting in the mediation.
Definitivamente, yes. Definitely.
We had a couple of questions circling around the issue of transparency and confidentiality, which is understandable, a bigger issue in the context of the mediation. One question, what mechanisms exist to guarantee the confidentiality of investment mediation? How can parties be confident that what is said and what is written by the parties and the mediator is kept absolutely confidential in the event an arbitration follows? So first part of the question is the guarantee the confidentiality of an investment mediation, and the second part is even so if it is followed up by an arbitration proceeding. Would you like to start, Carlos Jose?
Yeah, well, what we did is we started the negotiation process, or the mediation process, basically the negotiation process, by signing an agreement, a negotiation agreement, a negotiation protocol, establishing very clear terms of how the parties are going to behave during the negotiation, and to treat the conversations as confidential. And I think I mentioned this while I was speaking. And if needed, the parties would agree on releasing joint public statements on the terms they consider sufficient for the public opinion.
And in your experience, these agreements, the negotiation agreement, confidentiality agreement, joint statements that have been adhered to by the parties?
Yes. Mm-hmm. Yes, I think it worked very well.
Wolf, would you like to share some of your experiences on the topic?
Yeah, I think when it comes to mediation, I mean, there are different levels of confidentiality. I think one thing that is clear is for this type of process to be transparent, it's something that obviously is going to be more public. There will be more public type statements that have to be made. And I think, again, as part of the framework for the mediation process that will be agreed between the parties right at the outset is, how will public statements be made? And is there a media protocol that is put in place right at the outset? But I think within the mediation itself, I mean, one of the strengths of mediation, of course, is that the mediator can work with the parties and that there is confidentiality with respect to what the parties tell the mediator, because that's a real strength in mediation, because parties will be very reluctant to reveal their positions and their interest to the mediator if they feel that between themselves in the mediation that confidence will not be maintained. So I think we have to look at that confidence as something that has to be maintained within the mediation itself, but that, as Carlos Jose says, with respect to communications to the outside world, that there is an agreement as to how those communications be made. And I think parties tend to comply with that because they know that without doing it, there won't be any chance for a settlement to take place if their trust is breached in some way by something being said that took place within the mediation. I think when it comes to the arbitration and what is revealed in the arbitration, again, as Carlos Jose says, there's an agreement that's signed by the parties that maintains that confidentiality and that actually says that it's not to be used in any further proceedings. And again, that's an agreement. So in effect, there would be a breach of an agreement between the parties, which presumably could be enforced in some way if that were breached within the arbitration.
Maybe I can add to that. Under the ICSID Convention conciliation rules, when we look at the functions of the Conciliation Commission, we have an article in the ICSID review that deals with the incorporation of the IBA investor-state mediation rules in an ICSID conciliation process, which we think is possible. The ICSID Convention conciliation rules allow for that, and there we have a specific provision under the Convention regarding the confidentiality of information and its use in subsequent arbitration proceedings. Likewise, in the arbitration rules, we have the provision that somebody who has served as mediator or conciliator may not serve as arbitrators. So the system looks at that. We have one more area of question. I know we are over time, so I want to be mindful of participants' time allocated for this webinar. At the same time, I'm tremendously grateful for the large interest and the many, many more questions that we actually have here by audience participants. And we would like to address one topic that came in on questions, which is the enforcement. Kindly explain the good faith of states and investors in adhering to a mediated settlement in light of the fact that mediation settlements cannot be enforced the same way as awards can. Carlos Jose, would you like to take that question?
Well, sure. Good faith. I mean, of course, good faith between the states and investors in adhering to a mediated settlement is key. I think it's the most important part of the mediation process. If we get into a mediation process and then it's not complied, one of the parties that not comply with the agreement, then we don't have a dispute resolution. So if there's no good faith, there's no solution. If it happens to me as a state representative, I will tell the tribunal how the other party misbehaved while we were trying to reach an agreement through mediation. So I really doubt that a party will break its good faith in the solution.
Just to, Wolf, before I hand it over to you, one thing to add here. We've actually had a case in which an investor and an Eastern European state had reached a settlement, embodied that settlement in an award, and incorporated in that settlement agreement an ICSID arbitration clause on top. And later on, there was a dispute about the compliance with the settlement, and the party later initiated an ICSID investor-state arbitration arising out of that settlement. So there are options to that. Wolf, would you like to add something on your experience on good faith?
Yeah, I would say, and in my experience, certainly where you've got a negotiated settlement between parties, they tend to adhere to it because, as I said previously, the parties have reached that agreement. And unless something arises about interpretation, and I think in your case, probably, Frauke, it was more around the interpretation of what had to be done rather than one party simply saying, I'm not going to comply with the settlement. I think that's generally what might be the issue. As I said, there is an UNCITRAL working group right now looking at the enforcement of mediated settlements. It's too early to say whether that will reach any conclusion, but clearly there is some concern about that. Otherwise, UNCITRAL wouldn't be looking at that. And clearly, there may be other remedies that then become available for the enforcement. But enforcement's always an issue. As you know, of course, awards are more easily enforced because of the New Convention. But it's something that obviously is of concern. But I would say, largely, in most cases, the parties will comply with an agreed settlement.
One thing maybe to add, I promised our friend Anna Jobin-Brett, who was largely involved in the investor-state mediation rules of the IBA, to mention the UNCITRAL working group's progress just earlier this month in New York on the drafting of a convention on the recognition of mediated settlement. So in June of this year, the UNCITRAL working group will finalize its work, and that is June 25 to July 13. So the work is certainly underway. Within the ICSID context, I can return back to Article 26 and the option to have an ongoing mediation while an arbitration is pending, expressly stated by the parties' consent to such a mediation. The beauty then, of course, under the ICSID system is should the parties reach a settlement during the mediation process, such settlement could be incorporated into a settlement award by the tribunal with the benefits of the enforcement provision of the ICSID Convention. That is maybe one consideration. We are nearing the end of our webinar today. We really thank you for your active participation and the many questions that we have gotten from the audience. We will attempt to address them in writing and get back to you on these.
Yes.
We really think, Carlos Jose, you would like to add something?
No.
Yeah. You would like to add to Carlos, Jose, and Wolf will assist with the answers to the questions by audience participants. And I really thank you for taking the time and sharing your experience from your government view. And Wolf, thank you to you in London for taking the time and sharing your experience and all the insights you have on mediation in the investor-state dispute resolution context. On behalf of ICSID, I also would like to thank everyone to have joined us on this first ever webinar, and we look forward to continuing the series. Thank you.
Thank you.
Thank you. Thank you.